Order. Order.
The Draft Disclosure Scotland Act 2020, Consequential Provisions and Modifications Order 2025.
I call the Minister to move the motion.
Thank you, Sir John. I beg to move that the Draft Disclosure Scotland Act 2020 Consequential Provisions and Modifications Order 2025, which was laid on 11th of February, be approved. I'm grateful for this opportunity to debate this order today, and as with all the Scotland Act orders we've considered since the start of this Parliament, this is a result of collaborative working between the UK and Scottish governments. The order before us will be made, like many others, under Section 104 of the Scotland Act, which, following an Act of the Scottish Parliament, provides the power for consequential provisions to be made to the law relating to reserved matters or the laws elsewhere in the UK. Scotland Act orders are a demonstration, Sir John, of devolution in action, and I am pleased to say that this government has taken through 7 orders since we came to office in 2024. I'll now turn to the detail of the order. This order makes provisions in consequence of the changes the Disclosure Scotland Act 2020 has made to the existing disclosure regime in Scotland. The Disclosure Scotland Act, which I know many members may not be familiar with, concerns the regime for disclosures made by the Scottish ministers about a person's criminal history and other information held about them by police and law enforcement agencies, such as fingerprint records. It is a crucial piece of legislation that received cross-party support from all parties when it was passed by the Scottish Parliament and simplifies the system for disclosure in Scotland. For most people, they'll come across the disclosure system when they apply for, in Scotland, a PVG from Disclosure Scotland to often work or volunteer with children or vulnerable people. The order before us today ensures the continued provision of information from UK law enforcement bodies to the Scottish ministers for the purposes of the disclosure regime. This includes conviction information, cautions, relevant police information and records of fingerprints. This cross-border information transfer is necessary to ensure that Scottish ministers can exercise their vetting and barring functions efficiently and effectively. Importantly, it ensures that the public are protected. Turning to some of the individual provisions of the order, Part 2 places duties on the chief officers of UK law enforcement bodies in relation to disclosure information that are equivalent to the duties that the Disclosure Act places on the Chief Constable of Police Scotland. This ensures that the Chief Officer must provide information to Scottish ministers in the same way that the Chief Constable is required to do in Scotland. The law enforcement bodies to which this duty applies is outlined in Part 1 of the order. Part 2 also provides provisions for a statutory review process of other relevant information before it is disclosed to a third party. This is a central provision of the Disclosure Act intended to enhance proportionality of the disclosure regime. Finally, Part 3 of this order places further duties on law enforcement agencies to make other information, such as central records, personal data to verify identity and fingerprint records, available to the Scottish ministers. If passed today, this order will come into force on the 1st of April 2025, and guidance will be provided to UK law enforcement bodies before that date. Sir John, this order is about keeping our communities and our constituents in Scotland safe. Without it, there would be significant consequences for safeguarding across the UK, as the cross-border disclosure and information sharing arrangements that are already in place under the Police Act will no longer operate. This would put our communities at risk and undermine a system that has operated effectively across the UK for many years.
Thank you. The question is whether the committee has considered the Draft Disclosure Scotland Act 2020, Consequential Provisions and Modifications Order 2025. Opposition spokesman Harriet Cross.
Thank you very much. Thank you, Chair, and I'm grateful for the Minister's remarks. Disclosure functions are, of course, highly important and sensitive, and clearly they must work efficiently for the protection of those who are vulnerable, but also for those subject to disclosure requirements, whether individuals or organisations. As we understand it, the overarching aim of this draft order is to allow the continuation of the disclosure and safeguarding regime in Scotland and authorising the policy intentions of the primary legislation underpinning this SI, the Disclosure Scotland Act 2020. It does appear to be technical in nature for the most part, but it's also concerning that we're having to consider legislation to avert a situation where ineligible people or even small businesses would have been criminalised before the scheme even became a legal requirement. Clearly, we would not want people being criminalised before this, as it would be an uneven legal framework. I'd be grateful, therefore, if the Minister could address the following questions. Can the Minister please outline what conversations he has had with the Scottish Government, both on the proposed solution to the problems that have arisen and what steps the SNP Scottish Government are taking on their side? Secondly, does the Minister have confidence that the right people have been consulted and engaged with while trying to rectify this problem, and that the concerns have genuinely been listened to? What statistics can be offered on the information campaign of these impending changes in terms of the people reached and whether it has resulted in a shift to the level of engagement? And does he believe that the secondary legislation that the Scottish Government plans to bring forward will be properly collaborated with this draft order? Finally, given the complexities, can we be sure that the guidance due to be published will be genuinely clear and easily understood to smooth what has not been the most straightforward transition so far? Thank you.
Thank you, Sir John. I'll try to pick up on all of those questions, but if there's any that I don't, we'll make sure that we write to the member afterwards. Just in terms of, I'm not entirely sure I understand her point around the criminalisation. The Disclosure Act is obviously an act put forward by the Scottish Government, passed by the Scottish Parliament, and is really to simplify what is quite a complex landscape in terms of disclosure. It has been well received by stakeholders and others in terms of simplifying that, and as I mentioned in my opening speech, was passed unanimously and on a cross-party basis by all parties represented in this room in the Scottish Parliament, and is an important part of the Scottish Ministers being able to carry out those vetting and barring functions. In terms of the consultation, Disclosure Scotland have worked alongside officials in the Ministry of Justice, the Home Office, Ministry of Housing, Communities and Local Government, Department of Justice in Northern Ireland and the Welsh Government on the policy for and the drafting of this order. And I know, and that's just for this order. In terms of the Disclosure Scotland Act, which was introduced to the Scottish Parliament, I think I'm right in saying in 2019, there was obviously extensive consultation in advance of that with anyone affected, including, she mentioned in her speech, businesses and also with volunteer organisations and others who make extensive use of the system. She mentioned the information campaign. So as far as I understand it, obviously this has been run by Disclosure Scotland. As far as I understand it, the campaign has been running for 18 months. I don't have statistics to hand in terms of how that's operated, but that would be a question for the Scottish Government and not for the UK Government, and probably specifically for Disclosure Scotland. But I know that from discussions I have had, that over the past 18 months that campaign, especially with stakeholders who make use of this system, has been extensive, and they are waiting for this to come into force, and most people that have an interest in this are well prepared for this to come into force on the 1st of April. She also mentioned guidance. There will be guidance available before the 1st of April. That guidance is the guidance for the public bodies, the law enforcement agencies that are affected by this order. The guidance for how the vetting and how the Disclosure Act system, the PVG system, etc. will work has already, as I understand it, been provided to those stakeholders, and as I said a moment ago, they're expecting that to be implemented on the 1st of April. So the guidance referred to in my remarks is specifically about the guidance that will be offered to law enforcement agencies in the rest of the UK outside of Scotland about how they implement the Disclosure Scotland Act and how they respond to the duties that are placed upon them. She also mentioned secondary legislation in terms of additional legislation as a consequence of the Disclosure Scotland Act. This is obviously the order that will. This is the order that this Parliament and the House of Lords will consider this next week. In terms of secondary legislation, the Scottish Government might put through the Scottish Parliament. I think that's probably a question for them rather than us. But in terms of this order, this will be us discharging our responsibilities to ensure that the consequential provisions that can't be dealt with by the Scottish Parliament because of reserved legislation are dealt with in order that the system can carry on working effectively and can operate after the 1st of April. I hope that answers all of our questions. If it doesn't, I'm happy for her to intervene again, but or for us to write to her on anything that we may not have covered there.
That's fine. Thank you.
Thank you. Just looking round, just in case anyone else wanted to intervene. No one's caught my eye, so the question is that the committee has considered the draft Disclosure Scotland Act 2020, Consequential Provisions and Modifications Order 2025. As many of that opinion say aye.
Aye.
To the contrary, no. I think the ayes have it. The ayes have it. Order